Rule 1.8, Particular Conflicts. Rule 1.8 has a variety of particular rules that deal with situations in which the lawyer's and the client's interests conflict. Let us just quickly review them and discuss the rationale for any that are confusing. Subsection D deals with attorney-client business relations. An attorney may only enter into a business transaction with a client if all of the following conditions are met. The business arrangement is objectively fair to the client. The terms are fully disclosed to the client in writing in a manner that can be understood by the client. The client is advised in writing to seek independent counsel and is given time to do so. The client gives informed consent in writing signed by the client. This informed consent must include the essential terms of the deal, the lawyer's role in the deal, and whether the lawyer is representing the client in this transaction. The rationale for this rule is, again, the fiduciary duty the lawyer owes the client. The client depends on the attorney to advise and take care of his interests. So an attorney can never deal with a client in an arm's-length, business-like way. What does this rule cover? Any sort of business relation. If the attorney and client become friends and want to co-invest in a new venture, this rule applies. If the client is a startup business and wishes to pay the lawyer in stock rather than in cash for the fee, this rule applies. If the lawyer has a business affiliate with her law practice, say an estate planning lawyer owns a financial advising business, this rule applies. See comment 1 for more examples. Where it does not apply is when the client has a business open to the general public and the attorney decides to become a customer. For example, the attorney opens an account at the bank that is his client, or the attorney becomes a patient of the doctor who is her client. Subsection B provides that an attorney may not use any information he gained in the representation of the client to the disadvantage of the client. This is true whether using the information will help the lawyer or a third party, such as another client. This rule is a result of the attorney's fiduciary responsibility to the client. Using confidential client information in a way that could harm the client violates the attorney's duty of loyalty. How might this come up? Imagine the lawyer learns that the client is trying to lease space at a particular shopping mall. It would be improper for the lawyer to advise another client to buy that mall or lease empty space at that mall, thinking it would be a good investment in light of the first client's interests. However, this rule does not prohibit the lawyer from using such information gained in the representation of one client to help a second client where the first client will not be harmed. For example, if the attorney learns in a case that a particular judge interprets the rules in a certain way, the attorney may use this knowledge for the next client when he is before the same judge. Subsection B does provide 2 exceptions. 1, the client could give informed consent to the use of information that might disadvantage the client. And 2, other rules might permit or require the attorney to use the information to the disadvantage of the client. For example, as we have seen in Rule 1.6 regarding confidentiality, sometimes the attorney is permitted to breach confidentiality to prevent the client from harming another. This rule does not alter that option, nor requirements for whistleblowing that may exist under Rule 113 and rules regarding evidence in court. Subsection C provides that a lawyer must not solicit any substantial gift from a client or prepare an instrument, such as a will, giving the lawyer that gift. The exception is if the lawyer is closely related to the client, as a spouse, child, or grandchild. So, you may still write a will for your mother, even though you and your siblings will all share in the bequest. Comments 6 to 8 flesh out this rule. An attorney may have himself named as the executor of the client's will, provided Rule 1.7 conflicts of interest will not prohibit such an appointment. Also, this rule does not prohibit simple gifts such as holiday fruit baskets or chocolates. Subsection D is similar but less likely to come up. A lawyer may not negotiate literary or media rights to the client's story while representation is still ongoing. Comment 9 notes the inherent conflict of interest this presents. Subsection E is in some ways a curious rule. It prohibits the lawyer from providing financial assistance to a client in connection with pending or contemplated litigation. The only exceptions are that a lawyer may advance court costs and expenses of litigation, and a lawyer may pay the court costs and litigation expenses of an indigent client. Repayment of these costs are usually contingent upon the outcome. Thus, if the attorney accepts a tort action for a seriously injured individual, she can't advance him money to pay his mortgage to forestall foreclosure. This is true even if the value of his case is such that the monies advanced will surely be repaid. What is the rationale for this Scrooge-like provision? The rationale is that lawyers giving or loaning clients money would encourage them to pursue lawsuits that might not otherwise be brought. This is a throwback to the ancient prohibition of barity, champerty, and maintenance. A better rationale for this prohibition, in my view, is that allowing attorneys to buy clients will often lead to clients teaming up with the least scrupulous of attorneys. Clients will feel forced to go with the best deal. Competent lawyers who don't have such deep pockets will be unable to compete, to the detriment of clients overall. Check out the Utah version of this provision to see a slight difference. Subsection F deals with someone other than the client paying the lawyer's fees. A lawyer may not accept payment from a non-client unless the client gives informed consent, there is no interference with the attorney's independence or with the attorney-client relationship, and there is no breach in confidentiality. This means, of course, that the lawyer may not give the person paying the fees confidential information about the case, and the lawyer may not take direction from the person paying the fees. When will this come up? The parents of a juvenile charged with delinquency might retain an attorney for their child. Dad might pay the fees of a young adult child's divorce. There is also the case of the insurance company paying for the attorney to defend the insured who is sued, say a doctor for malpractice. In the latter case, however, the exact arrangement as to who is entitled to confidential information and who is entitled to make decisions about the case may be a matter for contract between the insured and the insurer. Even then, there are possible situations in which the interests of the insurance company and the interests of the insured diverge, and the lawyer must be aware of to whom he owes allegiance. Comments 11 and 12 apply, and note that the lawyer must ensure that receiving payment from someone other than the client does not create an impermissible conflict of interest. For example, if the mafia don pays for counsel to represent the alleged hitman, where the don may also be charged with murder, the attorney's loyalty in representing the alleged hitman may well be diminished by the attorney's greater loyalty to the mafia don. This same inquiry should be made with the corporation paying for the lawyer to represent both the corporate entity and the named corporate employee. Subsection G deals with aggregate settlements. When a lawyer represents two or more clients in a matter, the lawyer can arrange an aggregate settlement or plea deal only if all clients give informed consent, confirmed in writing, and signed by each client. Each client is entitled to know what deal all the other clients are getting. This prevents the lawyer from selling out one client to get an advantage for a different client. Differences in willingness to accept offers of settlement is one of the inherent risks of common representation and should be discussed with each client in getting informed consent to common representation in the first place. Subsection H deals with the attorney wanting to settle a claim of malpractice with a client or former client. The lawyer must not make an agreement prospectively limiting the lawyer's liability unless the client is independently represented in making that agreement. The reasons for this should be clear. If the retainer agreement seeks to limit the lawyer's liability, it can undermine competent and diligent representation. Once the attorney has begun the representation or after representation has concluded, issues of malpractice may arise. The attorney may settle a claim or prospective claim for liability with an unrepresented client only if the client is advised in writing of the desirability of having independent legal counsel and is given time to consult with independent counsel. Subsection I prohibits the attorney from acquiring a proprietary interest in the case. This rule has its basis in the common law of champerty and maintenance and is designed to prevent the attorney from getting too great an interest in the representation. However, it does not prohibit contingent fees, nor does it prohibit the attorney obtaining an attorney's lien to secure her fee or expense. Section J provides that the lawyer may not have a sexual relationship with the client unless the sexual relationship predated the attorney-client relationship. The reason, again, is that the attorney owes the client fiduciary duties and must put the client's interests ahead of his own. Developing an intimate relationship with the client is fraught with the possibility of conflicts of interest, preventing the lawyer from properly putting the client's interests first. Interestingly, even in the case of corporate clients, a sexual relationship with any constituent who supervises, directs, or regularly consults with the attorney violates this rule. The rules clearly consider the attorney as the powerful person in the relationship and the client as invariably placed at risk. Check out the Utah version of this provision and consider which version you think is better. Finally, subsection K makes it clear that lawyer equals firm for all of the above provisions except the final one. Any business relationship by one lawyer in the firm is imputed to all the other lawyers in the firm. However, because the prohibition of sexual relations is personal, it is not imputed to all other members of the firm. This concludes the discussion of Rule 1.8. Please listen to the lecture regarding lawyer fees and fiduciary responsibilities covering Rules 1.5 and 1.15.